Right, so we're going to get started then, and thank you everyone online for joining. Thank you everyone in the room. This event is being held to commemorate International Human Rights Day in conjunction with the end of our 50th year as Chambers. It felt like a fitting opportunity to hold this event. Particularly because of the political landscape that we're in. Human Rights Day theme for this year is Human Rights Our Everyday Essentials. And what it describes on the United Nations website, hi all, do come in, is in this period of turbulence and unpredictability, where many feel a growing sense of insecurity, disaffection, and alienation, the theme of Human Rights Day is to reaffirm the values of human rights and show that they remain a winning proposition for humanity. Through this campaign, we aim to re-engage people with human rights by showing how they shape our daily lives, often in ways we may not always notice. Too often taken for granted or seen as abstract ideas, human rights are the essentials we rely on every day. This is timely, I would suggest, because news circles were reporting at lunchtime today. It was the Council of Europe's most recent meeting of the 47 member states. And in that meeting, 27 of them, including the UK, signed their own individual letter, which The Guardian describes as being aligned with some of Europe's hardline governments calling for change to allow Rwanda-style migration deals. The UK has joined with some of Europe's hardline governments in calling for human rights laws to be constrained to allow for migration deals with third countries and more foreign criminals to be deported. This includes reviewing the meaning of inhuman and degrading treatment under Article 3, as well as how we define weight to be placed on the nature and seriousness of offences in the context of Article 8 claims, where a criminal may have ties to the host nation. So that's our background for International Human Rights Day. I'm delighted to welcome our panel of speakers. I should introduce myself first. I'm Jodie Blackstock. I co-convene our Civil Liberties and Human Rights team. And we're not, ironically, talking too much about that kind of work today, despite the fact that this is promoted by the Civil Liberties team. So if we have time, I'm hoping for a few heckles from the back from Mr. Simlet KC, as a consequence of the many cases he's done in this area. But I think it's right to acknowledge in our 50 cases publication the many cases that we're not going to showcase today around the development in inquiries and inquests, enabling access to justice for bereaved and survivors, in equality and discrimination rights, in housing, and across many other areas that members of Chambers practice in, supported by all of our solicitors and NGO clients to achieve the successes we're going to talk about today. So I'm delighted to have with me Sonali Naik on my left here, who's going to cover the immigration aspects of this work. Henry Blaxland, who's a stalwart member of Chambers since the beginning, to cover crime and protest. Amanda Meusz, to the right, he's going to cover what we don't necessarily hear so much of about is the children and family rights aspects of our work, because of course the Family Court is dealing with human rights every day. And finally on the screen we have Amanda Weston, KC, who is also going to give us a consideration of some of her cases which have addressed detention and the way people are treated in detention across the different places where it is in operation. So we're going to start with Amanda. Just to introduce her briefly to you, Amanda is, her practice focuses on all areas of the law relating to children, including provision of services to children and young people. She has extensive experience in public law matters across the range of serious and complex cases in the context of children and family rights. She's often instruction in deprivation of liberties cases as well. And I think it's important to reflect that her practice has developed in a trauma-informed and trauma-responsive way, so that her approach to cases involving children and families is really focused on that aspect of effective participation in cases. So Amanda, can I hand over to you? We've got some background slides here, as opposed to presentational slides from the publication.
Thank you. Thank you for asking me to speak. I was really pleased, in fact, to be asked to speak at this event, because in my experience, it is not really well known by other practitioners just how important human rights are to the work that we do, or I do as a family practitioner. So most of the work I do is public law children work, where the state intervenes in family life with the aim of protecting children from significant harm. The state doesn't always achieve that aim. And human rights are absolutely central to the work that family practitioners do, or certainly should be. And not just Article 6 and Article 8, which are fairly obviously engaged, but in many of the cases we do as family practitioners, Article 5 is engaged. There is a huge increase in traumatised young people being deprived of their liberty with the aim of protecting them from harm, either in the dole's court or in secure accommodation. And what we do know is that many of those young people are further traumatised by their experience in the care system and under the deprivation of liberty orders. And I think Amanda Weston is going to talk to you about a case we did together called RET. Article 9 is not infrequently engaged. There are often conflicts between families' beliefs, religious beliefs, and a child's best interests. The other article that is, in my view, really frequently engaged but overlooked is Article 14. In my experience, I regularly see blatant discrimination against Roma Gypsy traveller families. I see on a regular basis the criminalisation and adultification of traumatised young, I'm going to call them global majority children, because I think that's I heard that term at a conference, and it struck me not only as true, but a term that we don't use. So I don't want to talk about a minority, but the global majority who are routinely discriminated against in my view, in the family justice system. Article 2, the right to life. And I'm going to talk to you a little bit about a case of AB that is really dear to my heart and features in our brochure. But before I do that, just a quick overview of HW, which was another Supreme Court case, which reminds the courts that when intervening in family life and when whether to make a care order or not. And by that I mean the removal of a child from his or her family, potentially permanently. The court must consider whether it is necessary and proportionate to make that order. It's something that is enshrined in law, but in practice does not always, in my view, work. And as a member of this chambers, it's something that I find myself fighting for on an almost daily basis. It's really interesting to hear Jodie talk about human rights being an everyday essential. When we think about human rights in the context of family life, I think it's really important that we remind everyone that it really is an everyday essential. And if those who complain about human rights were to actually think about how they would feel if their family life was interfered with in the way that I often see in the work that I do, they might take a very different view. So that's a sort of quick overview, but I do want to talk about the case of AB. The case of AB involved a 4-year-old child. He was 4 at the time of that case. There had been previous proceedings under the inherent jurisdiction relating to the permission to withdraw medical treatment. The local authority intervened at a point when AB's parents were in conflict with the NHS Hospital Trust. They did not want to their child to come home because they felt that the package of care being offered by their local authority and the health commissioning board was insufficient to protect AB's interest, that he would suffer if he did not have the right package of care. In my view, the local authority wrongly invoked child protection procedures because of that dispute with the NHS Trust and the local authority over a package of care. And in my view, there was a building of a case against this family that was clearly discriminatory in relation to this child's disability. He had a complex neurodevelopmental neurological disorder and needed a very high level of support and care. The case at first instance culminated with the making of the care order. The care plan for that child was to move him to a hospice type environment. In that placement, we were told that the child would not be given the procedures that were keeping him alive. So his parents were regularly suctioning him to clear his airways, had refused to give him high levels of drugs that would suppress the workings of his central nervous system. The local authority claimed that in giving him that high level of care in terms of suctioning him and refusing high levels of medication, they were prolonging his life and causing him significant harm in prolonging his life, which is a rather bizarre claim, that to keep a child alive, you're causing that child significant harm. But that was how the case was run. Bizarrely, in my view, the guardian, the children's guardians are appointed in children's cases to protect a child's best interests, supported the local authority in their applications. And as I've said, the local authority was successful. Care order was made. Fortunately, I was able to secure an immediate stay on that order. Now that all happened nearly 9 years ago. I remember distinctly because it was my daughter's 11th birthday. My daughter will be 20 in April. That little boy would have died. Without a doubt, he would have died if he had been removed from his parents and placed in the hospice, because he would not have received the care and treatment his parents were giving him. That little boy is still alive today. He is at home. He is loved. Every year I receive a Christmas card and photograph from his family. And it is the case that is closest to my heart, and I think encompasses everything that I've been talking about in terms of human rights being an everyday essential, and just the importance of the work that we as family practitioners do. I don't think really I can say any more than that little boy is still alive, nearly 9 years on.
Thank you, Amanda. It's such a heartwarming story to hear, but such a battle.
It was a battle.
And it's these sorts of cases that we're all involved in, isn't it? Where everyone thinks that they're doing the best thing, they're talking about the best interests, they're following their procedure, and yet, unless you've got someone like yourself, or perhaps like you in the audience, who are, trying to do what really is best for the clients that we're working for, we don't necessarily get to the point where you're at now with that. So it's nice to hear that kind of outcome, and I imagine these sorts of cases continue even now, 9 years later, all the time, unfortunately.
I think we do. I think we see an increase in local authorities bringing child protection cases when in fact there's a battle over support and care.
Are there any questions for Amanda at this point? Because she's got to head off to another very important meeting. It feels a bit in isolation, but I just wanted to give you the chance if there were any burning thoughts at this point. Well, do feel free to leave when you have to, Amanda.
All right, enjoy the rest of the
Thank you.
Yeah.
Oh, sorry, I didn't see.
No, sorry, I was really interested to hear about how Jodie mentioned your practice had been informed as well by your trauma and sort of informed advocacy and your approach. To what extent would you recommend junior barristers or people who are starting in the field of human rights to receive training in trauma?
I think it's essential. I think it's absolutely essential to become not just trauma informed, but trauma responsive. And I think that in all aspects of work where we have traumatized clients, it is important to understand how trauma impacts on their functioning and their participation in not just court proceedings, but in the assessments that lead up to court proceedings, because very often trauma is missed or misunderstood. So very typical trauma responses are misunderstood as lack of engagement, as being untruthful, as being deceptive. So often, and I think this happens across the board in all areas of practice, traumatised individuals are asked, well, why didn't you report that at the first opportunity? Why can't you give a coherent story? Why does your story change? And I think that is just as applicable to the work that I do, and I'm sure the work that you all do in crime, in immigration, in detention. Traumatised people do not respond in necessarily a way that is seen as logical, because the thinking brain is not working, because trauma responses are in action. So I think it's absolutely essential that people not just understand how trauma impacts on functioning, but they practice in a trauma responsive way.
Yes, I completely agree with that. And I think we all have to be really aware that our clients become overwhelmed. And if we don't have the tools to be aware of that and know how to manage it, then the courtroom is not a place where they can properly participate in the case.
Or even
In the assessments, yes, exactly. But it's not just about how we communicate with our clients, it's about how we advocate for the needs of those clients in the court environment. Right, let's move on. Oh, sorry, yes.
Thank you very much. What would be your advice to the conducting solicitors to develop the case? Because I understand you do get to contribute at the very final stage, maybe in the court, but especially what would be your advice to the conducting solicitors? Please, thank you.
I think that it's really important that solicitors become trauma informed and trauma aware. There are lots of training programs out there, so as a starting point, I think learning about motivational interviewing when working with clients, so ways of bringing out the real instructions, true instructions, having something that nobody has but time, and putting time in at the beginning. And I appreciate that is very often not funded, so that we do so much work that we are not remunerated for, but being able to put that time in at the beginning, I think pays dividends at the end. The other thing in the work that I do, I'm very often, if not instructed right at the beginning, solicitors consult me and we work together. So if you can find friendly barristers who are willing to help you right at the beginning of cases, then I would do that too.
Thank you.
Thanks very much. So now I'm going to move on to Amanda Weston, who's on the screen with us, who is going to talk to us about detention, as I said, and of course detention is one of the severest interferences with human rights we have, taking away all of the other parts of our lives. Amanda's going to focus on a couple of cases involving secure children's provision and possibly, if we have time, validity of bail orders in that context as well. But just to introduce Amanda for us, it's fair to say Amanda's the leading public and administrative law silk. She co-authors Judicial Review Practical Guide from Nexus, is a member of the A Panel Preferred Counsel who act for the Equality and Human Rights Commission, and was shortlisted for KC of the Year at the Family Law Awards last year, as well as Human Rights and Public Law Silk of the Year in 2021 of the Chambers UK Bar Awards. Amanda practices across all sorts of human rights areas, so we're delighted that she's able to join us today, even from her place of intended rest.
Thanks very much.
Save that much, I'm afraid, Amanda.
Thanks. No, that's great. Thanks very much. I was actually, it's really lovely to have an opportunity to talk about good things that human rights law has done. As we're lawyers, we always think that human rights is about law, and your introduction makes it really clear, talking about the everyday impacts, that actually it's not about law at all. It's hardly ever about law. It's only about the law in a tiny, tiny fraction of cases that human rights affects. And so I've picked two cases which, in my view, are exemplars of that. The first one is a case I did with Amanda Meusz, who's just spoken, and it's a case which it shows how human rights helps public authorities grapple with conflicts concerning the most fundamental rights concerning children. And then the other case I'm going to come to is going to talk a little bit about how it's not always apparent that human rights is in the background of cases which are decided on a common law basis, and that's because of the normative power of human rights, especially in Article 5, as I'll describe. So the first case It was a case called Re-T. And unusually in that case, both Amanda and I acted for the local authority. And what was at stake was the local authority's dilemma about finding a home that a child with very complex needs wouldn't want to run away from. And what that meant was that they needed to come up with a bespoke solution because there was nothing off the peg. There was nothing that they could turn to. Secure welfare provision for children that need a firm boundary like that to protect them. It's horribly underfunded. And as Amanda has just explained, quite often the experience of a child of being deprived of their liberty in such a context is damaging, is traumatizing. So what this local authority had to do, they were on the cusp of two very important rights. They knew that they had to put a boundary around this child to stop her running away. But they also knew that it could be harmful to take a child's liberty away, especially a child coming up to the age of 16, getting more mature, getting more independent. On the other hand, the evidence was that that child would barrel into situations which posed a very clear Article 3 risk. I can't go into the details, well, the court didn't go into the details of them, but suffice to say, they were the kind of horrendous risks to a young person of exploitation of the most horrible kind. So what was a local authority to do? And T was about that because Article 5 places restrictions on the circumstances in which the state can deprive a child of their liberty or anybody of their liberty. And one of the restrictions is that it has to be further to pursuant to a process prescribed by law. And the problem about the kind of bespoke provision that Re-T needed was that it wasn't prescribed by law. It couldn't be, because the law prescribed that a child could be placed in a secure welfare provision, but there wasn't any secure welfare provision. And there certainly wasn't any provision which was appropriate for this child with this child's needs. So they had a clash between the child's best interests, the law which meant that they would be depriving her of her liberty outside the legal framework, and Article 3, which meant if they didn't deprive her of her liberty outside the legal framework, which on some views would be breaking the law because it would be putting a child in a place which wasn't subject to, hadn't been registered and gone through the registration and oversight process. But if they didn't do that, then the risk was Article 3 harm. And what the Re-T did was look at the hierarchy of rights, at the least worst option with the assistance of the Strasbourg case law, and came up with a solution which was an absolute fudge. But what the court couldn't do was make the government pay for adequate amounts of provision or provide resources for enough bespoke provision within the law. I think it's fair to say that there's been a fair shake-up of the law since then, and the circumstances in which the local authority is forced to do something like that, place a child in an unregistered provision, are now fewer, but still a problem. And so what the court grappled with in Re-T was a very sensitive analysis of what's the more important thing? Is it that there's compliance with the legal framework, or is it that in these circumstances we have to apply an approach which is generous to to what prescribed by law is, and is cautious about leaving Article 3 risks at large for children. So what's important to remember about that case is that the tools that the local authority had to make the right decisions for that child were the human rights tools. And the answer they came to, the court decided, was the right answer. And that's the most important thing to remember about RETI. Local authorities have to deal with these kinds of situations all day, every day, and the complex problems that children have and develop, and the kinds of situations that children have to be protected from become ever more sophisticated and difficult to handle. And they touch on the hard line between liberty and freedom, and the state's intervention with that. And I, for one, am very grateful that the local authority that we dealt with, that we represented, had a very good understanding of where those human rights conflict and what's important and what's not, and were able to do the right thing for that child. The other case that I wanted to talk about is a case called Majera. And it seemed so straightforward when it started. It really didn't seem contentious at all. Mr. Majera, I mean, background facts, you're probably all aware of this already. But in this country, we have indefinite detention of migrants. One of the reasons why Strasbourg says that that's compliant with the human rights is because people in immigration detention have a right to bail, the right to apply for bail, and they have a right to get a prompt review of the legality of their detention. And also we have a set of common law principles which broadly align with the reasonableness factors that Strasbourg would take into account, and those are the Hardyal-Singh principles. So Article 5 is always underpinning not just individual decisions to detain, but the framework which is available to challenge that detention. Obviously, it's something which has developed over centuries through the common law, but the modern law, as I've just explained, very much aligns with the protections against interferences with liberty, which are set out in the Convention. So Mr. Majera got his bail from a first-tier tribunal judge, and as a matter of constitutional law, tribunal judges are independent, part of the independent judiciary. They're not an administrative layer. He was granted bail, and the Secretary of State for the Home Department took issue with one of the conditions which was attached to that bail. And so rather than go back to and get the bail varied, they just issued another notice which they purported to superimpose over the grant of bail, the order granting bail that the first-tier tribunal had made. When we remonstrated about that, we said, well, actually, you can't do that because it's like a court order and everything. We thought that was quite standard. Call me old-fashioned. And they then argued that actually they can do what they like because that order wasn't valid. It expired. They came up with a variety of reasons. By the time we got to court on judicial review, because we were complaining about the condition being imposed, the court, their position was that the order was defective, and because they had decided it was defective in a technical way, then they didn't have to follow it, which also seemed quite outre at the time, because court orders have to be followed until they're set aside. However, it took going all the way up to the Supreme Court to get the Supreme Court to say that in terms. And although they don't make specific reference to Article 5, it did form part of the background. And it's very important that if they had ruled that the Secretary of State for the Home Department could have just ignored that order, then that would have meant that all the Strasbourg law that says that the indefinite detention regime is lawful because of the right of access, prompt access to an independent, impartial tribunal to review the legitimacy of that detention, would have fallen away, would have got into trouble. And that it's important to remember that sometimes the courts don't like to mention human rights. They like to say it's all about the common law. but it's the normative power of human rights that we all have to remember in these difficult and complex times. That's all I had to say, if that's all right.
Wonderful. Thank you so much, Amanda. Hopefully you'll be able to hang around for some questions at the end, if that's okay there.
Yeah, I'll be
link's
here.
working perfectly. You can hear you and see you brilliantly. So if that's all right, we'd love to keep you with us. Can I now hand over to Sonali, who is going to chart us through the choppy waters of the immigration world. I'm sure you all know that Sonali is one of the team responsible for stemming off the Rwanda law from last year, and it's unfortunate that that seems to now be back on the agenda, even with a Labour government. Sonali is joint head of chambers here at Garden Court. She practices in public law cases in all aspects of immigration, asylum and nationality. She's ranked in Chambers and Partners and Legal 500 for that work. She's a senior practitioner with over 30 years of experience and was appointed King's Counsel in 2018, practicing at all levels, including the European Court of Human Rights, Supreme Court, Court of Appeal, Administrative Court and Upper Tribunal. Going from the top down to the bottom there, that was an interesting way of doing it.
Whichever way you want to go, that's fine.
Yeah. So I'll hand over to you, please.
Thank you very much. So I've chosen to talk about this is because we're celebrating the work of Garden Court today, and because we're celebrating our 50th anniversary, and because we are also celebrating and marking human rights. I've chosen to start with the case of M versus the Home Office, which obviously, even though I am over 30 years old, even I couldn't have done this case in 1993 probably. Stephen Simblett was a pupil, and Steph was here. I wasn't even in Chambers there, but I had just qualified, and I think at the time, 1993, I was working at the Refugee Legal Centre. But the reason, I haven't got the slide up. The reason this case is important is because it was the first case which really cemented the government's accountability in terms of interim injunctions and their obligations to the court, and paved the way ultimately in 2022 for the way in which the Rwanda flights were stopped by ultimately by the Court of Appeal in our domestic framework. So, I was certainly old enough to remember the case, and it was very significant because. And two barristers from Barrister Rick Scannell, who's no longer in Chambers, no longer practicing lawyer, in fact, he took this case to the House of Lords, along with, he was led then by Stephen Sedley, as he was QC, and then ultimately by Sir Sidney Kentridge in the House of Lords. But this is the reason it's important. This is about an Article 3 case, somebody who alleges an asylum seeker, as in Rwanda at that time, 1993, alleges removal will breach their Article 3 rights. And they go to the court and get an injunction. But in this case, the person, M, was removed. And he was actually on his way. There was an interim place. He was removed to Paris, and then he was going to be removed on to the DRC. And the judge made the original injunction. The Secretary of State was then told about the injunction, but actually didn't, in fact, follow through with what counsel's undertaking to the court, which was that he wouldn't be removed. Now, in fact, as it transpired, the barrister who made that undertaking said, actually, I made that undertaking without any instructions. I wasn't able to give that undertaking. Anyway, the M was removed. In the middle of the night, what we now know as the pyjama injunction, of which we've done many, or certainly I have. His solicitors and barristers went back to the judge and asked for another injunction to order his return, and the judge granted that injunction. Ultimately, Secretary of State was told about that injunction. By this point, M had already been removed, and the Secretary of State then went back to the court and asked for that injunction to be discharged, because she said the Secretary of State said Mr. Kenneth Baker as it was, you can't make that injunction against me because there's no jurisdiction to do that against an officer of the Crown. So really important And that was where the case would have ended had it not been for, in fact, the applicant solicitors, those Winstanley Burgess, Sonia Burgess, previously known as David Burgess, Winstanley Burgess solicitors, made an application to the court to say, I want to introduce committal proceedings against the Home Office and the Secretary of State in respect of breach of the undertaking not to remove him, and in fact breach of the order to requiring his return. And the lower court said, well, no, you can't bring that case against the Home Office, or sorry, against the Crown. The Crown is immune from prosecution. And the Court of Appeal allowed the appeal by majority that the applicant brought. And ultimately, in the House of Lords, the court found, and this is absolutely critical, that even before there was the Crown Proceedings Act, an officer of the Crown could be personally liable in a tort committed, even though he'd authorised it, as long as he was acting in an official capacity. So that is the foundational basis on which you can then say to a court now that I want to bring a claim. Once I've got my order, that I can enforce that order against the official acting in his official capacity. And that had that lasting impact on how we then go to court, what we now know is feels like a routine basis on getting injunctions and injunctions against in this context, in Article 3 context, and in the immigration context, in relation to ministers against the Home Office. And so this ultimately meant that it required a lawful consideration for the asylum claims to be made. So if you bring that injunction in the context of somebody saying, if you remove me to Rwanda, at the time, it's going to be, my human rights are going to be violated in Rwanda, and therefore I want an injunction to prevent my removal there. And those who acted in the Rwanda litigation, of which probably half of the bar, immigration bar or public law bar was involved, those people came so close to being removed. I mean, my clients came within half an hour of being removed. But for the confidence of the court to say, we know that and this was the Court of Appeal, the confidence to say we have the authority to grant the injunction. The invitation I made to the Court of Appeal that night was, look, if you want to grant the injunction, you can just grant it until tomorrow when we'll come back and have a proper argument about this. But with 30 minutes to go, where does the balance of convenience lie? And that, particularly in a heightened threshold case where we're concerned with Article 3 rights. So, Rick Scannell, David Burgess or Sonia Burgess and Stephen Sedley laying that groundwork in 1993 allows us the freedom to practice and go to the court with confidence and not worried about whether they're going to be threatened with somebody saying the Home Office have immunity from suit. So that is why we put this case into the Garden Court list of 50 cases. And that's why I feel, it is a privilege to inherit the cases that others before me have done and argued. It's a privilege to rely on those precedents to further the advance of human rights for our individual clients. So again, those of you who weren't around in 1993, and many of you in this room are much too young for that, it's a really interesting case to go back and look at. And when you look through the booklet that you've got, in relation to our 50 cases, I think you'll find some great inspiration there, because the inspiration, I think, was particularly David Burgess or Sonia Burgess at the time, going and get the judge out of bed. That's what he would do. He would go, she later became she, but at the time he would go to a judge's house and find the judge to go make the injunction, go to the Garrick Club and get the judge out of dinner. Wow. Because in those days there wasn't the out of hours procedure, and it's partly because of that kind of effort that we ended up with the out of hours procedure, because judges were fed up with having their dinners interrupted. I definitely remember going to get judges out to dinner at Gray's Inn myself, but that's the kind of dedication to cause. And had it not been for that, you can see in the chronology for just going back and making the judge do something, and then when he got overturned, going and saying, right, committal proceedings. That's, it's a sort of, diligent slog to getting the right answer in the human rights case. So I just commend that kind of dedication and bravery. It is brave, actually. It's not just dedication. You have to have real nerves of steel. So thank you to those barristers who are involved in that. And I just wanted to briefly mention the second case. It's not only because I'm going to blow my own trumpet. It's because I want to talk about a case that I'd actually done myself, but also because just in relation to Bioku Betts, but you don't have to look at it. The only other reason for mentioning Bioku Betts was because this was a case from 2008 in the House of Lords, which is in relation to family life and the rights to family life being not just the person who had the appeal, but the person who's the family as a whole, which seems really uncontroversial now, but at the time in 2008, we needed the House of Lords to say that. And the only reason I particularly mention now, and I'm not conscious of the time, but just because this case was very recently examined, of course, in the Gaza family reunion case of IA. So the Court of Appeal just 2 weeks ago gave judgment in IA. By saying, well, yes, Bioku Betts is right insofar as it goes, which is, yes, you have to look at the family life rights altogether. But then what does it really mean if you're talking about adult dependence? You have to show more than the usual or emotional ties and a degree of dependence. And what that dependence is a question of evidence. And so they effectively, despite the IA having won his appeal, ultimately concluded that the tribunal had gone wrong by saying, well, they'd attached too great a weight to the prospect of the development of family life rather than the family life that he had already had with his adult sibling. So, Bioku Betts, the facts of Bioku Betts was an adult child, he was a student and his mother, and the tribunal had made some really important facts about interdependency between the mother and the child, but he wasn't even living at home full time. So, because he was away at university during the week. So the contrast with how it was interpreted in 2008 to that most recent judgment of somebody living in a war zone in Gaza, trying to join his family here, is quite stark. But I don't think it's necessarily all is lost, because what we're really hoping to do is that if we can get evidence about the nature and degree of the dependency, I think there is room there, difficult though it may be, to just to emphasise in an individual appeal that what the level of dependency or how those additional elements are met. But the court in IA spent a lot of time trying to emphasise the immigration control justification under Article 8.2. So, and as Jodie introduced, we've obviously seen other changes are afoot at the Council of Europe at the moment. But so it just again shows you that 20 years later, things haven't changed, but we rely on what we learned and how we learned them in order to build cases on human rights principles. And I still think that holds good, even though we've changed how many years passed since 2008. Yes, well, nearly 20.
Yes, and it perhaps is an indication that the court doesn't always find in favour of the person remaining when the government is complaining about the use of Article 8. We do necessarily have to do a lot of work to succeed in these cases. Stephen?
I just wanted to chime in on this theme of standing on other people's shoulders. Amanda, in passing, referred to the case of Hardial Singh.
Yes.
It's a fact, sort of, a foundational case. In fact, that is a habeas corpus case that Terry Munyard did in 1978 or 1977 or something, by essentially going to court, applying for the release of somebody who was detained under the Immigration Act, where there was, for the reasons that Sonali and Amanda have mentioned, no principled controls over the detention. You were either in detention or you weren't, and getting habeas corpus on the basis that this person actually, the purpose for detaining couldn't be shown to be made out, and 50 years later, people are still going to court with that argument, and it's sort of just part of the furniture, but it actually comes from somebody doing exactly what Sonali's been talking about people doing, requiring somebody to just go back to first principles and look at what is the rule of law and what are people entitled to expect from a legal system.
Indeed. Mr. Justice Wolfe in 1984, that case.
Wow,
No,
there we
not as
are.
old as I thought then.
But I think it's also really important for those of you who, because this is that was obviously a pre-Human Rights Act case, and we were looking back at M versus the Home Office. So that's using those common law principles, but seeing them now and trying to emphasise it. It's very hard to suggest that common law can give us everything that we want when we have a human rights framework, and that is how our case law has developed. I know there's a Lord Briggs is a fan of that because he gave his speech. But each member of the Supreme Court was giving their own view on sort of which side of the line they fall. But anyway.
Indeed. If you want to read more about that, it's number 27 in the publication. So, last but certainly by no means least, Henry is going to talk to us a little bit about the criminal justice side of practice in chambers. And of course, Article 6, Article 5 are the core rights that are practiced every day in the criminal courts by members of chambers, by our solicitors, by many people across the criminal justice system, which remains under threat in terms of the backlogs, but also now in terms of jury trial. So, Henry,
get a spiel this
Henry,
very eminent.
It's just eminent. He's done
It's
lots of
old,
things.
you know, I'm a stalwart.
All the big ones, basically, all the big ones. And I was delighted to work with you in a case which we didn't succeed on, sadly. In the right to compensation, we still continue to work on this. Miscarriages of justice, of course, include some of the worst cases that have occurred in the last 50 years, and they're still happening, still coming out. Andrew Malkinson last year, for example, 23 actually. What happens when people are released from custody is that their lives begin to spiral after 20 years in a confined environment. How do you deal with that? And many of these gentlemen here at the Birmingham 6 struggled immensely, despite at that time having access to compensation. Now it is incredibly hard to access compensation at all because you have to demonstrate effectively that you were innocent of the crime you did not commit, according to the criminal courts. We took that argument, Henry and I, on behalf of justice, all the way to the Grand Chamber, and sadly failed at the final hurdle on a presumption of innocence angle. But we are hopeful that this government will do something about this, even if they are collapsing everything else around us.
More in the hope than expectation.
So, Henry's going to talk to us, I imagine, if you wanted to, about Derek Bentley, and then a bit about protest.
I'm not actually. I'm
Okay,
going to talk about something completely different. I want to really talk about the importance of human rights, okay, and its application to criminal law. Because I spent half of my practicing in the criminal courts before the Human Rights Act was introduced. And I think it's worth just standing back for a moment and thinking about that. And it is extraordinary that there is no written constitution in this country. I mean, we bequeath the constitution to various colonies which were occupied by the British state, and the constitutions of those countries very often include ingredients, if not mirror, contents of the European Convention, but we didn't have it. So the question which I think should be posed, and I can only really deal with it in the context of criminal law, is has it made a difference? Has it actually advanced the practice of criminal law in a progressive way? And I think the answer is yes, but. It's provided, I think, an invaluable framework to develop the law, and it has helped, albeit in a relatively small way, to provide protections. But we need, as a matter of principle, to be seen to be standing up for the Human Rights Act, because there is no doubt about it, the moves to either repeal or to reform the Human Rights Act are the voices of reaction. And we all know that. And it's part of our job as progressive lawyers, and we shouldn't be ashamed of being progressive lawyers, to take a stand on this. So I'm going to give you a whistle-stop tour. I'm not going to talk about, I mean, Derek Bentley was a fantastic and very interesting case, but it's got nothing to do, or very little to do, with the Human Rights Act. So I'm going to give you a whistle-stop tour, if I might. I know it's the end of the evening and your concentration may be dwindling a bit, but it may help if I just look, if I can, at the headlines in relation to the application of the Human Rights Act to criminal law. And I want to start with a case which I did shortly before I took Silk, when I was led by the late great Courtney Griffiths, KC. Case called Davis, Johnson and Rowe. Raphael Rowe. Davis, Johnson and Rowe was the case of the M25-3. Some people here may remember it. It was heavily politicised. It was a criminal gang who were raiding high-value properties on the outskirts of the M25, and during the course of one of their outings, somebody was killed. All right, that was the background, so it's quite a tough case. One of the defendants, Raphael Rowe, has gone on to become a celebrated journalist and presenter. The reason that the case came to the Court of Appeal ultimately because it was discovered that one of the main witness was a police informant, which hadn't been disclosed at the time. So there was we were able to argue, a breach of Article 6 because of the failure of disclosure. Went to the European Court, who ruled there was a breach of Article 6, and then the question was, what effect does the fact that the European Court had ruled there's a breach of Article 6 have on the test for an appeal court, the safety of the conviction, right? That was the question, sort of a big principle of consideration. And I'm going to come back to that in relation to a recent case. But the Court of Appeal essentially fudged it. They said, we argued that in fact, a finding of a violation of Article 6 should mean the conviction is unsafe. The Court of Appeal said, no, it doesn't quite go that far. It's relevant, but it's not a trump card. But they did push the conviction. So that had an impact. The other impact it's had in the application of Article 6 to the right to silence, I think has been to some extent significant because it's provided a structure for arguing or limiting the availability of the adverse inference provisions. I don't know how many people here are criminal lawyers. You know what I'm talking about, the adverse inference. But effectively, the right to silence was seriously qualified by the fact that you now are told you have a right not to say anything, have a right not to give evidence, but the jury may draw a conclusion against you if you don't give evidence or if you haven't spoken in an interview, putting it crudely. The directions which a judge is obliged to give to a jury when somebody has not given evidence are influenced by, affected by decision of the European Court in the case of Cowan, which effectively means that, in fact, I would argue that the adverse inferences has been significantly, the significance of it has been significantly diluted as a direct result of the decision of the European Court. So that's a beneficial aspect of it. The question of what's called reverse burdens, in other words, many criminal statutes have a provision of lawful excuse, for example, lawful excuse, the burdens on the defendant to establish a lawful excuse. By direct reference to Article 6, it was decided that certainly the defendant has an evidential burden to raise the subject, but once it's been raised, the prosecution must disprove it. That was as a direct result of Article 6 being invoked. So yes, so it helped in that way. This is a whistle-stop tour, so I'm cutting corners, but human trafficking. Victims of trafficking who are prosecuted, all right? There have been a number of cases involving that. I've been involved in quite a few of them, okay? They've involved the application of the European conventions, the European anti-trafficking conventions, and there have been two of them, the directive and previously the European anti-trafficking convention itself, but also they've involved the application of Article 4, which is the prohibition against slavery. And I want to give you one example of that. I'm going to come back to the Davis, Rowe and Johnson point in a moment. Case of VCL. VCL was a gardener in a cannabis factory. He'd been trafficked to this country, as many people, and it's well known for years and years and years that part of the, for some reason, the Vietnamese have got a monopoly in cannabis growing. I don't quite know how they managed to carve that out, but they have. But they use mainly young people who've been paid a debt bond in Vietnam, brought over to this country. When they arrive, thinking they're going to be able to, lead a fruitful life, they find themselves being told to work in a cannabis factory, which is, firstly, it's dangerous. Very often the places are dangerous. They find they can't leave, or if they can theoretically leave, they're still under the control of the traffickers. All right, so VCL was one of these. 2014, his case came in front of a court judge, who was then the Lord Chief Justice, and the complaint was made, he was 17 at the time, the complaint was made that he shouldn't have been prosecuted because he was a victim of trafficking. No, the judge said, the court said, it was relevant to sentencing, but it didn't mean that he shouldn't have been prosecuted, right? The law moved on. There were further a number of cases. About 5 years later, maybe less than that, VCL's case was sent back to the Court of Appeal by the Criminal Cases Review Commission, and it was listed with 4 other cases in front of the next, or the new Lord Chief Justice, who was John Thomas, Lord Thomas. Yes, anyway, I won't get on to Lord Thomas, but you came up in front of him, all right? And the problem we had was, of course, having to overturn the decision of the previous Lord Chief Justice. Well, we had some fresh evidence, but not only that, but the law has since been developed, particularly in relation to the protection afforded to children under the trafficking conventions. Not good enough, said Lord Thomas, and dismissed the appeal. And we refused a certificate to go to the certificate for the case involved a point of law of public importance to go to the Supreme Court. So we went to the European Court, and we won. We won on the basis that there was a violation of Article 6 and a violation of Article 4, and the Court of Appeal on 2 occasions had failed to protect his Article 6 rights. That's 2 Lords Chief Justice who'd failed to protect his rights. So I was then asked to advise about whether or not he should pursue a further application to the Criminal Cases Review Commission. I said, of course. Wrote quite a short advice, sent it off to the CCRC in 2022, and 2 weeks ago, the case was referred back to the Court of Appeal by the CCRC. And of course, it raises the same point as was raised in Davis, Johnson and Rowe, which is what is the effect of a decision of the ECHR on the safety of the conviction. Now, I would hope that in this case, it's a slam dunk, because having effectively decided that the Court of Appeal on 2 separate occasions has failed to protect his rights, it's difficult to see how the Court of Appeal can do it again. But victory! We've got there. Victory over 2 different constitutions of the Court of Appeal and 2 different Lords Chief Justice who had mixed reputations, if I can put it like that, within among those of us who practice in criminal law. Right, okay, I'm sorry about this, but I want to deal with the case of Ziegler, which is in the book, I see.
Yeah, if you can bear with us, everyone. We did start late because we were waiting for people to come in.
Rabbiting on.
You're not ranting on, we just started late, that's all.
Right to protest, all right? Ziegler was the high point, right to protest. I led Owen Greenhall, the very wonderful Owen Greenhall from these chambers, who is Mr. Protest Law, known as the Prof in chambers. In this case, it was some protesters against the arms trade who had blocked an access route to the Excel Centre, where there is a biannual trade fair. You can get all sorts of stuff there, torture equipment, goodness knows what, anything you may like, which may come in useful when you're wanting to lock people up. And anyway, that's what they were protesting against. They blocked a road. And the heroic district judge they were charged with obstruction of the highway, and there's a defence of lawful excuse to obstruction of the highway. And the heroic district judge dismissed the case against them on the basis that it would be a disproportionate interference with their Article 10 rights, and that they did have a lawful excuse. Prosecution appealed to the divisional court. The divisional court embarked upon an extensive analysis of the application of the human rights principles to the law of protest, but then, to our great disappointment, allowed the appeal. So we appealed to the Supreme Court. I have to say I did this with some trepidation because the divisional court judgment was quite good in terms of the actual principle, even though we lost on the facts. But we went off to the Supreme Court. I was leading Owen and Linneran Grover from Matrix, who heroically represented the South African government in the Gaza litigation in the International Court of Justice, who is absolutely brilliant person, although she's not in our chambers. And we won. And the case of Ziegler is the high point, effectively, of the application or the importance of the application of Article 10 rights of convention rights. All right. I won't go into the details of the case. The problem, of course, is that since then, the courts have just rowed back from it in a completely disingenuous way. And we're not quite back to square one, but we're not in a particularly good place now. I mean, there were various decisions. They were shocked and appalled by the ambit of the judgment. One of the most important aspects of the decision in that case was that when human rights are when the Article 10 is engaged, in particular, the finder of fact, be it magistrates or even a jury, should embark upon not just a decision on the facts of the case, but a decision as to whether or not a conviction would be a proportionate interference with your Article 10 rights. Okay, that was really the absolute nugget from the decision in Ziegler. Well, 2 weeks ago, sorry about this, man. 2 weeks ago, I was back in the Supreme Court, again with Erin Greenlaw, in a case dealing with Section 12 of the Terrorism Act, which is the offence of inviting support for a prescribed organisation. And the diluted form of that section, which makes it an offence to express an opinion which is supportive of a prescribed organisation, and at the same time being reckless as to whether or not any person who hears it would support an organisation. Anyway, we'll wait to see where we get to in the Supreme Court on that point. We've argued that it's the new section is incompatible, but it gave us an opportunity to deal with that whole territory, and in particular, an opportunity to deal with this question of whether or not juries should be directed that not only must they decide whether or not you're guilty, but whether or not it would be proportionate to convict you. And there have been cases in which judges have directed juries in that way. So that's a good example, actually, of the way in which Article 10, 6, and so on and so forth. And I should mention Article 7, because in the most recent case, we argued that in fact the law is too unclear, doesn't allow people to understand sufficiently clearly, what they can and they can't say. That was effectively, at the end of the day, our central point, and that's important. I mean, so yes, coming back to the point I made in the first place, I'm sorry, Jodie, I've come on far too long, but coming back to the point I made in the first place, yes, it's very important to hang on to the Human Rights Act, and yes, human rights principles do make a difference and can be made to make a difference. And it will be a sad day if we lose it all.
Thank you very much, Henry. And hopefully, what you all have heard from this evening, those in the room and those online, is there is work to be done, but there are successes. And if we build on those successes, because that's what we do in common law jurisdiction, there are things that are important to defend and to treat as everyday norms, ultimately. So thank you all very much for coming, and I hope you take with enthusiasm the principle of Human Rights Day forward in your work.